Of the State of Michigan versus Jordan Cronk, docket number 20-292FC. And this was the time set for a hearing on the people's motion to consolidate trials. Mr. Silverthorne, someone told me they thought this would be a plea. My law clerk told me that this morning. Is that correct?
That's correct, Your Honor.
Okay. Mr. Cronk, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Cronk, how far did you go in school?
I graduated.
Okay, very good. Okay. You have the right to an attorney. You are represented by Mr. Silverthorne, and Mr. Silverthorne, I have the information in front of me. I don't know which count or counts this is a plea to.
Your Honor, I believe it's a plea to count 1, larceny from a motor vehicle, and then the added count 4, assault with a dangerous weapon.
Very good. And then you'll waive reading of the balance?
Yes, Your Honor.
Ms. Allen, would you read them counts 1 and 4, please?
In the people of the state of Michigan versus Jordan Cronk, file 20-292-FC, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about April 11th, 2020, at 209 Baker Street, City of Lansing, Ingham County, the defendant did in count 1 commit the offense of larceny by stealing or unlawfully removing or taking catalytic converters that was in or on a motor vehicle that belonged to Michael Javid, contrary to Michigan law. This is a felony punishable by up to 5 years and or $10,000. And in count 4, did make an assault upon Michael Javid with a dangerous weapon, to wit, an electric saw, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to Michigan law. This is a felony punishable by up to 4 years and or $2,000. DNA to be taken upon arrest, and a consecutive sentence may be imposed under Michigan law if the assault was committed in a place of confinement. We ask the court take notice. We will be proceeding on these two with the defendant as a habitual second offender. We ask the court take notice. The defendant was previously convicted of a felony or an attempt to commit a felony in that on or about April 8th, 2016. He was convicted of the offense of possession of methamphetamine in violation of Michigan law in the 29th Circuit Court for Clinton County, State of Michigan. This makes the penalty on each of these crimes 1.5 times the maximum sentence, and the maximum penalty cannot be less than the maximum term for a first conviction. And I will ask the court to take note, the defendant currently is on parole, so he is not receiving credit on this while he's been sitting in jail, but I just want to make sure in terms of a consecutive sentence that that's put on the record as well.
All right, thank you. Mr. Cronk, you're being charged here with larceny from a motor vehicle and assault with a dangerous weapon or felonious assault. Those are each felonies, and because the prosecutor is proceeding against you as a habitual second offender, the larceny from a motor vehicle is punishable by up to 7.5 years in prison, the felonious assault up to 6 years in prison. And then also, as the prosecutor noted, if you're on parole, it's a mandatory consecutive sentence. Have you had enough time to talk about these charges with your attorney?
Yes, ma'am.
Do you understand the charges against you?
Yes, ma'am.
Do you have any questions about what we're doing?
No, ma'am.
How do you want to plead?
Guilty.
If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with a trial. That includes, you'll be giving up the right to a trial by jury. If you didn't want trial by jury, trial by judge. You're giving up the right to be presumed innocent and to require the prosecutor to prove your guilt beyond a reasonable doubt. You're giving up the right to have the witnesses against you appear at the trial and to be able to cross-examine them, as well as the right to have this court order any witnesses that you might have to appear at the trial. Also, you're giving up your right to remain silent at the trial and not to have your silence used against you, or if you wanted to, your right to testify at the trial. Also, if you plead guilty, you don't get an automatic right to appeal your case to the higher court. Instead, you have to ask them to hear the case, and they have to agree. And then also, if you plead guilty, there's a lot of issues that you actually cannot appeal to the higher court, unlike going to trial, where people go to trial if they get convicted, they can appeal a whole bunch of things. So, do you understand those rights?
Yes, can I ask you a question real quick though? Because I don't really
Of course you
understand the
can.
process and stuff. I
Yes.
guess I agreed to a 24 months deal. Is that in effect right now or?
Yeah.
Mr. Yeah, we haven't gotten to the statement of the plea bargain yet, sir.
Okay, all right, I'm sorry. This stuff sounds a little scary to me, so I gotta.
And
No, I
and
know.
I'm sorry to interrupt, Your Honor. If I had been standing next to him, I could elbow him, but I can't do that.
Yeah, no, I understand, Mr. Kronk. We'll get there in one more minute to the part that I know you want to hear. Okay, so the other thing I have to tell you though first is if I accept your plea, it means you can't come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes, ma'am.
It also means you can't come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes, ma'am.
Is there a plea agreement, Ms. Allen?
Yes, Your Honor. In exchange for the defendant's plea of guilty to count 1 and the added count 4 in the amended information as habitual second offender, the people agreed to dismiss the balance of the charges in this case, and we agreed to dismiss in full his other file 20-503-FH. With the agreement, he will pay restitution to that victim in the amount of $495.51. There's also a sentence agreement pursuant to People versus Killebrew that the defendant's minimum sentence on counts 1 and 4 will be fixed at 24 months in the Michigan Department of Corrections.
Oh, there it is. I was just a little impatient.
Okay, so that's what you wanted to hear. Is that a full and complete statement, Mr. Silverthorne?
Yes, it is, Your Honor. Excuse me.
Okay, now, Mr. Kronk, is that your understanding of the agreement also?
Yes, ma'am.
So now, that's all what you were thinking, that's what you thought the agreement was, and you agree with it, correct?
Yes.
Okay. Now, there is a part about this agreement that pertains to your sentence, and that is that the low end of your sentence would be fixed at 24 months in prison. Do you understand that if I decided not to go along with that, I would tell you before I sentenced you, and I would give you a chance to take back this whole plea and start over? You got all that?
Yes, ma'am.
Has anyone promised you anything else that hasn't been said here right now in order to get you to plead guilty?
No.
Anyone used any threats?
No.
Is it your own choice to do this?
Yes.
And are you pleading guilty because you believe you are guilty of these offenses?
Yes.
Okay, so let's talk first about the larceny from a motor vehicle. Tell me what you did on or about April 11 of this year.
Well, I found a junkyard and I attempted to cut off the catalytic converter on it.
Okay. Did you actually succeed in cutting it off?
No.
Okay. Well, did you at some point, on some vehicle, did you steal a catalytic converter?
The vehicle I was in had a catalytic converter in it, so they said, so that's how they put it all together.
Okay, and so did you steal that catalytic converter that was in the vehicle you were in?
I was driving, but yeah, I mean, I was part of it.
Okay, so there were others involved besides you?
Yes.
And you
But I
played
was
a
out
part
taking
in
it.
it?
I was out taking them. I mean, I'm guilty of that. I was going to take that catalytic converter. There's no doubt about that.
Yeah, I know, but the charge is that you did take something from a motor vehicle, not that you tried to, or you thought about it, or you took some action towards it, but that you did take something. So you told me about one that you participated in, is that correct?
Yeah, it was in that same junkyard. I mean,
Okay, so same location, and you had some part in that?
yeah, I mean, it was the same vehicle. It was,
All right. And what did you do?
Cut it off. And I
You
went-
cut it
was
off,
up-
okay.
Yeah, cut it off,
And
went
you-
back to get the other one.
And you were stealing that one?
Yes,
So you had no permission from whoever owned the junkyard or the car to take it, correct?
no, I didn't.
Okay. And then, what happened with this electric saw, the other charge?
The owner and his buddy heard me out there, dinking around in the back of the junkyard, and they walked up on me. He was videotaping me. I took the phone out of his hand, pushed stop record, gave the phone back to him. He punched me in the mouth. I guess I bit his finger. Then his friend started coming at me, and I turned on the saw. And then I started waving it at them, and they both tackled me.
Oh,
Held me to the ground until the cops came.
you turned on the saw to like threaten him with it?
No, I just tried to keep him back. Just try to, you know what I mean? Because they were both coming at me, so I was waving it at them.
Well, you can't plead guilty and claim self-defense. So are you,
I guess I hit him in the side. When we went to the
okay?
ground.
I'm sorry?
I hit him in the side or something when I went to the ground, so I guess that's how they're claiming this.
Well, no, they're claiming it because they're saying it's an assault with a dangerous weapon, like the saw. So did you do something to threaten him with the saw?
I don't think so. I waved it at him, that's what I did.
You waved
What do
it
you
at
want me to say? Yeah, I waved it at him.
I don't want you to say anything. I just have to take a factual basis. And you can't say, I assaulted someone, but I did it in self-defense and expect me to take your plea, because I can't do that. So you threatened him with the saw, correct? Mr. Crab?
Mr. Kronk, do you want to speak?
Yeah, I don't know, I can't lie about what I did, that's what I did.
Okay.
I
And
didn't cut him.
No, no one's saying you did. You threatened him with a saw, and are you claiming that you did it in self-defense?
Yes. No, I mean, I don't know what you want me to say.
Do you want to take over,
tried
Mr. Silverthorne?
Yes, I don't need to speak to him, but if I may elicit, Your
Go
Honor.
ahead.
Mr. Kronk, you were stealing their catalytic converters, correct?
Yeah,
They were upset about that, correct?
yeah,
They wanted to prevent you from stealing the catalytic converters. And to that end, they wanted to apprehend you, didn't they?
yeah.
And to keep them away from you, you had that catalytic converter, which is powerful enough to saw off a pipe, and you waved it at them to keep them away from you, didn't you?
It was a hacksaw, but yes, I did.
Okay. And so the purpose of that was to scare them off so they wouldn't stop you and apprehend you in the act of stealing their catalytic converter, correct?
Correct.
Your Honor,
All right.
I believe
And all-
that is a factual basis.
And all of that happened at 209 Baker Street in Lansing, Ingham County.
Yes, ma'am.
The court, has the court complied with MCR 6.302, Ms. Allen?
Yes, Your Honor.
Mr. Silverthorne,
Yes, Your Honor.
are you aware of any promises, threats, or inducements other than those already placed on the record, Ms. Allen?
No, Your Honor.
Mr. Silverthorne?
No, Your Honor.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea. It's supported by the testimony. The plea is accepted. Sentencing date is Monday, November 30th at 3:30, if that works for you, Mr. Silverthorne.
It does, Your Honor.
Can you check now or can you check later with your client and let us know if he'll consent to a remote sentencing?
I will check right now, Your Honor.
Okay.
Mr. Kronk? Are you there?
I'm here.
Would you consent to having the sentencing conducted in the same manner that this plea has been conducted, which is by remote
Yeah.
electronic means. So you
Yes.
don't, you're not requiring that we physically bring you to court for sentencing, is that correct?
No, not at all.
Thank you.
Okay, thank you. I'll probably ask you to confirm that again at the sentencing date, but that'll be on November 30th. And in the meantime, Mr. Kronk, someone from probation is going to probably set up this similar kind of a conference with you to interview you for the report that I'll use for sentencing, so you should just be aware that that's going to happen before that sentencing date. Do you have any questions?
Yeah, Your Honor, does this always take this long to do? I mean, 4 weeks, a
It
month
does,
between
but you
each
won't
court
give me a
date?
factual basis.
Huh.
I'm sorry, I used up so much of your time.
No, you're fine. I'm just wondering if that's how it always works, but all right.
Yeah, I'm required to take a factual basis, so you've got to tell me in your own words what makes you guilty of the offense. And if you tell me someone's coming after you and you're trying to scare them away with a saw, I got a problem with that, so.
No, I'm not talking about that. I'm talking about in between court dates, Your Honor.
Oh, yeah, that takes a long time because the probation department has to talk to you, they have to do an investigation into your background, and they have to write a report that, you know, tells me everything that I need to know for sentencing.
Oh, okay. That's all I was wondering. It wasn't